Case 1. Craig Michael Wood Hailey. On February 18, 2014, a 10-year-old girl named Hailey Owens was walking near her home in Springfield, Missouri. It was the middle of the afternoon. She was in a residential neighborhood, the kind of street where children walk freely, where neighbors know each other by name, where the ordinariness of the surroundings creates the quiet assumption of safety that most people in most American cities extend to the streets directly outside their front doors. Witnesses saw what happened next. They saw Hailey grabbed. They saw her pulled into a truck. They saw the truck drive away. They called police immediately with everything they had: the vehicle description, the direction of travel, the details of what they had witnessed in the moments that would define what came next for the entire city of Springfield. Springfield police launched a full emergency response within minutes. The community mobilized with the speed that only the disappearance of a child produces. Schools went into lockdown across the city. Parents reached for their phones. Every available resource was directed toward finding a 10-year-old girl who had been taken from her residential street in broad daylight on an ordinary Tuesday afternoon. Craig Michael Wood was a teacher and football coach at a Springfield area school. He was a man whose professional life had placed him in regular, trusted contact with children and families across the community. He was known. He was embedded in the institutional life of a city that sent its children to his school and to his practice field. He was, by every outward description, exactly the kind of person that communities build trust around. Following the witness descriptions and the direction of travel that had been reported, investigators arrived at Wood's home within hours of Hailey's disappearance. They found her inside. She had been kidnapped. She had been raped. She had been murdered. She was in the basement of the home of a man who coached youth sports and taught in a Springfield school. The crime did not require years to solve. It did not require DNA testing of archived evidence from cold case storage or genealogical database searches through decades of unsolved files. It required witnesses who had been present, investigators who moved quickly, and the address that the evidence pointed to within hours of the abduction. Craig Michael Wood was arrested the same day Hailey Owens disappeared. What Springfield then had to process, and what the trial that followed required the entire community to sit through, was not the mystery of who had taken Hailey Owens. That question had been answered on day one. What the trial required was a full and public accounting of what had happened inside that house in the hours between the moment the truck pulled away from her street and the moment investigators knocked on Wood's front door. It was an accounting that the jury heard, that the courtroom absorbed, and that Springfield has carried with it in the years since the verdict came in. The deliberation was not lengthy. The evidence did not leave significant room for the kind of uncertainty that produces extended jury deliberations. Wood was convicted of kidnapping, rape, and first-degree murder. The jury's recommendation was death. The court sentenced him accordingly. Final outcome: Craig Michael Wood remains on Missouri's death row as of early 2026, where he has spent 8 years and 89 days following his conviction for the kidnapping, rape, and murder of Hailey Owens. His attorneys have pursued the capital appeals process through the Missouri court system. No execution date has been set at this stage of the proceedings. Hailey Owens was 10 years old. She was walking near her home on a Tuesday afternoon in February in Springfield, Missouri. She was seen by witnesses. She was taken in the open, in daylight, on a residential street, by a man whose name her community knew and whose job had been to protect children like her. Springfield has not forgotten what happened to her. Missouri's death row holds the man responsible for making sure that it never could. Case 2. Richard Emery. Not every case on death row arrives wrapped in the complexity of decades-long cold case investigations, or the kind of extraordinary legal circumstances that make courtroom observers stop and reach for something to write on. Some arrive with the grim simplicity of a crime that left little room for ambiguity, a relationship, a home, and a decision that ended lives. Richard Emery murdered his girlfriend and her family members inside their home. The crime was rooted in the most common ground that domestic violence grows from: an intimate relationship, and what that relationship became when it turned dangerous. His girlfriend's family was present in their own home when Emery arrived. Their presence in that space was not a provocation. It was not a threat. It was simply the fact of being home, in a place where they had every right to be and every reasonable expectation of safety. The investigation that followed identified Emery without significant ambiguity. The relationship between the parties was documented. The evidence assembled against him was sufficient to bring a capital prosecution before a Missouri jury. That jury heard the account of what had happened inside the home, who the victims were, what their connection to Emery had been, and the nature of the violence he had brought into a space where people should have been unreachable. The jury convicted him. The court sentenced him to death. He arrived on Missouri's death row 3 years and 158 days ago, one of the newest residents in a system that also houses men who were sentenced to death before he was a teenager. Final outcome: Richard Emery remains on Missouri's death row as of early 2026. His case has barely entered the Capitol appeals process, the mandatory series of legal reviews that follows every death sentence in Missouri and that typically extends across many years. His girlfriend's family was killed in their own home. The sentence the jury imposed is on record. The process that will determine whether and when it is carried out has only just begun. Case 3: Joshua Rocha. 137 days. That is how long Joshua Rocha has been on Missouri's death row as of early 2026. Of all the cases in this episode, his is the most recent, a conviction so fresh that the courtroom proceedings that produced his death sentence are still clearly visible in the public record. The families of everyone involved still close to everything the trial required them to endure. The North Kansas City Police Department serves a community in the Kansas City metropolitan area. It is a mid-sized agency, the kind of department where officers build careers in a specific place, where they come to know their beats and the rhythms of the communities they serve, and where the death of a fellow officer does not arrive as an abstraction, but as a rupture in the institution and in the lives of everyone who wears the same uniform. Officer Daniel Vasquez was performing the duties of his job when he encountered Joshua Rocha. He was in uniform. He was serving his community in the way that his oath and his department required of him. The encounter ended with Officer Vasquez dead and Rocha fleeing the consequences of what he had done. The investigation that follows the killing of a uniformed officer in Missouri, as in every state, mobilizes resources at a scale and speed that reflects the institutional weight of such crimes. The killing of a police officer in the performance of their duty is classified under Missouri law in a way that makes it eligible for capital prosecution, and that classification carries with it every tool the state has available to bring the case to the conclusion the law allows. Joshua Rocha was identified, charged, and prosecuted for the capital murder of Officer Daniel Vasquez. The trial produced a conviction. The jury recommended death. The court imposed the sentence. 137 days ago, Rocha arrived on Missouri's death row as its newest resident, assigned to a cell in a system that also houses men who were sentenced to death for crimes committed in a different decade, in a different Missouri, under a justice system that looked different in almost every respect except for the finality of the sentence it was capable of imposing. Final outcome: Joshua Rocha remains on Missouri's death row as of early 2026, where he has spent 137 days following his conviction for the murder of North Kansas City Police Officer Daniel Vasquez. His appeals process has barely begun. The legal road ahead of him is measured in years at minimum and potentially in decades. Officer Daniel Vasquez was killed while doing his job. His department, his family, and his community are living with that loss, while the system works through every legal stage that stands between a death sentence and whatever resolution Missouri's courts eventually deliver. Case 4. Vincent McFadden. There is a version of the Vincent McFadden story that begins with Leslie Addison, an 18-year-old woman, the sister of his girlfriend, shot and killed in a crime that sent McFadden to death row and kept him there for nearly 21 years. That version is accurate. That version is serious. But it is not where the story actually begins. The story begins in 2002. In 2002, Vincent McFadden committed a fatal shooting. A person died. Missouri's justice system did what justice systems do. It investigated, it prosecuted, and it arrived at a sentence. That sentence was not death. The legal determination made about McFadden's first killing placed him back in Missouri's world rather than on its death row. The case was processed. The record was made. And the system moved forward under the assumption that it had done what it was designed to do. Then he shot Leslie Addison. Leslie Addison was 18 years old. Her connection to McFadden ran entirely through family. She was the sister of the woman he was in a relationship with. She had not placed herself in conflict with him. She was not the source of whatever grievance or instability had produced the violence that ended her life. She was young. She was connected to him through her sister, and she was fatally shot by a man who had already, within the documented and publicly available record of Missouri's courts, killed someone before. The prosecution that followed brought both facts into the courtroom simultaneously. The jury that heard McFadden's capital case heard about an 18-year-old woman who had been shot dead, and about a prior fatal shooting that sat behind everything like a shadow. The prosecution did not need to exaggerate. The pattern, 2 fatal shootings, 1 man, was part of the full picture the jury was asked to evaluate when deciding what Vincent McFadden deserved. They sentenced him to death. He has been on Missouri's death row for 20 years and 350 days. The question that cases like McFadden's place in front of criminal justice systems is not comfortable, but it is important. When a prior killing produces a sentence that does not permanently remove a person from society, and when that person then kills again, how does the system account for what the first decision made possible? That question has no clean answer in McFadden's case. It rarely does in any of the cases where it applies. Final outcome. Vincent McFadden remains on Missouri's death row as of early 2026, where he has spent nearly 21 years following his conviction for the murder of Leslie Addison. No execution date has been set. Leslie Addison was 18 years old. She was killed by a man who had already committed a fatal shooting in 2002. The jury that sentenced McFadden to death knew that fact when they reached their decision. So does everyone who reads the full record of this case. Case 5. Roosevelt Pollard. In 1999, 14 years after Roosevelt Pollard arrived on Missouri's death row for the murder of Richard Ford, an Arkansas businessman, a Missouri court made a formal legal determination about him. Not about his guilt, which had already been decided. Not about his sentence, which had already been imposed. About his mind. Pollard had been diagnosed with paranoid schizophrenia. The diagnosis had been part of his documented record for years before the 1999 ruling. When the court formally examined the question of his competency, it arrived at a conclusion with a specific and precise legal meaning. Pollard was incompetent to be executed. Incompetent, in the constitutional sense that matters most in a capital case, to understand why the state intended to end his life, and what the sentence imposed upon him actually required. That ruling created a situation that Missouri's death penalty system has spent more than 2 decades failing to fully resolve. The crime itself was not ambiguous. Richard Ford was an Arkansas businessman who came to Missouri and did not go home. Pollard murdered him. The investigation established his responsibility with sufficient clarity to bring a capital prosecution. The jury that heard the evidence returned a verdict of capital murder. The judge imposed the sentence of death. That was 1985. Pollard arrived on death row that year and has been there ever since. But the Eighth Amendment of the United States Constitution, as interpreted by the Supreme Court in Ford versus Wainwright in 1986, does not allow the state to execute a person who cannot understand the nature and reason for their punishment. Pollard's diagnosis and his 1999 competency ruling placed him squarely within the legal protection that decision established. Missouri cannot carry out his sentence. It has also never formally commuted it. It has simply continued to hold him on death row, in a legal state that satisfies neither the promise of justice the original verdict implied nor the constitutional requirement that should have forced a different outcome by now. For more than 40 years, Roosevelt Pollard has been on Missouri's death row. He was there before most of the correctional officers who currently supervise him were born. He was there when the Supreme Court decided Ford versus Wainwright. He was there when it decided Atkins versus Virginia. He remains there now, diagnosed, adjudicated incompetent, and held in a permanent legal suspension that the state has shown no urgency to end in either direction. Final outcome: Roosevelt Pollard remains on Missouri's death row as of early 2026, where he has spent more than 40 years following his conviction for the murder of Richard Ford. He has been diagnosed with paranoid schizophrenia and was ruled incompetent to be executed in 1999. No execution has been carried out. No formal commutation has been issued. Richard Ford, the Arkansas businessman whose murder sent Pollard to death row in 1985, has been gone for 4 decades. The man convicted of killing him is still alive, held in a system that sentenced him to die, then determined it legally could not carry that sentence out, and has not produced another answer in the 26 years since. Case 6. Charles Lee Mathenia. In 1984, 2 elderly sisters were murdered in Missouri. Daisy Nash was 72 years old. Her sister Luana Bailey was 70. They were killed by a man named Charles Lee Mathenia in a crime that the state investigated, prosecuted, and resolved with a death sentence. That sentence was handed down. Mathenia went to death row. The case appeared in 1984 to have reached its conclusion. 10 years later, in 1994, a court made a determination about Charles Lee Mathenia that had not been made before his trial, before the jury delivered its verdict, or before the judge imposed the sentence that sent him to death row. Mathenia was declared mentally disabled. The sequence of that timing is the most consequential fact in this case. He was not declared mentally disabled before 12 jurors decided his fate. He was not declared mentally disabled before a judge sentenced him to death. He was declared mentally disabled 10 years after all of those things had already happened, 10 years into a death sentence, after a decade on death row, after the case had long since been treated by the system as fully and finally resolved. In 2002, the United States Supreme Court handed down its ruling in Atkins versus Virginia. The decision was clear. Executing an intellectually disabled person constituted cruel and unusual punishment under the 8th Amendment of the Constitution. The ruling applied retroactively, reaching back through every active death row in the country, and requiring courts to revisit cases where intellectual disability had been identified or could be established. Mathenia's 1994 finding placed him directly within the framework that Atkins established. His intellectual disability had been formally declared 8 years before the Supreme Court made that declaration constitutionally significant. The ruling should have provided a clear and relatively swift pathway to a commuted sentence. What it produced, instead, was a legal process that has extended across additional years and decades, without delivering the clean resolution that the constitutional prohibition on his execution seemed to guarantee. Daisy Nash and Luana Bailey were 72 and 70 years old when they were killed. They were sisters. They were elderly women whose age made them among the most vulnerable possible victims of the crime Mathenia committed against them. They were murdered in 1984. Their killer was declared mentally disabled in 1994. The Supreme Court ruled in 2002 that people like him could not be executed. And as of early 2026, Charles Lee Mathenia has been on Missouri's death row for more than 41 years, longer than many of the people watching this episode have been alive. Final outcome: Charles Lee Mathenia remains on Missouri's death row as of early 2026, where he has spent more than 41 years following his conviction for the murders of Daisy Nash and Luana Bailey. He was declared mentally disabled in 1994, a decade after his trial and conviction. The Supreme Court's 2002 ruling in Atkins v. Virginia prohibits the execution of intellectually disabled individuals under the Constitution. The formal legal resolution of his continued presence on death row has not been completed. Daisy Nash was 72 years old. Luana Bailey was 70. They were sisters. They were murdered in 1984. Their killer has been on death row for every single year that has passed since. Case 7. William Theodore Bolich, Jr. In 1983, an 18-year-old girl named Jody Harless was murdered in Kansas City, Missouri. She was young. The investigation that followed identified her killer. His name was William Theodore Bolich, Jr. He was tried, convicted of capital murder, and sentenced to death. He arrived on Missouri's death row in 1984. What happened next is one of the most extraordinary sequences of events in the history of American capital punishment. A story that begins with a routine legal proceeding and ends with a plane in a Missouri field, and a death sentence that the law has declared can never move forward, because the only person who could move it is gone. For more than a decade after his arrival on death row, Bolich worked through the standard capital appeals process. The appeals moved through the courts. The courts reviewed and ruled. The years accumulated. And then, in 1997, as Bolich's legal options narrowed and an execution date became a realistic near-term prospect, Missouri Governor Mel Carnahan granted him a stay of execution. A gubernatorial stay is a formal legal action. The governor exercises an authority granted by the state constitution to pause the movement toward an execution and allow additional time for legal review or clemency consideration. Governor Carnahan exercised that authority in 1997 on behalf of William Theodore Bolich, Jr. It was formal. It was documented. It was entered into the legal record of the case. And it became, 3 years later, the source of one of the most unusual legal predicaments in the history of the American death penalty. On October 17, 2000, Governor Mel Carnahan boarded a small aircraft with his son and a campaign aide. They were flying to a political event. The aircraft went down near Hillsboro, Missouri. There were no survivors. Governor Carnahan was killed. In the immediate aftermath of his death, the legal situation facing William Theodore Bolich, Jr.'s case came into focus in a way that no one had anticipated, and that the legal system had not been designed to address. A court examined the circumstances and arrived at a conclusion that was legally precise and humanly extraordinary in equal measure. The stay of execution that Governor Carnahan had granted in 1997 could only be lifted by the governor who had issued it. Gubernatorial authority in Missouri as it applied to this specific legal instrument was personal to the individual who had exercised it. Carnahan had granted the stay. Only Carnahan could lift it. Carnahan was dead. The stay was therefore, as a matter of law, permanent. Not because any court had reviewed Bolich's case and found a reason to spare him. Not because any new evidence had emerged that cast doubt on his conviction. Not because any legal principle had been established that protected him from execution, but because a small aircraft had gone down in a Missouri field on an October night, and the man who had been holding the key that could unlock the next step in the process had taken that key with him. Subsequent Governor Jay Nixon's office examined the situation and reached the only practical conclusion available: William Theodore Bolich, Jr. would not be executed. He would live out the remainder of his life in Missouri's prison system. That was not a pardon. It was not a formal commutation issued through the standard legal process. It was an acknowledgement that the mechanism required to move toward an execution had been locked 3 years before the crash by a gubernatorial action that the crash had made legally impossible to undo. William Theodore Bolich, Jr., is Missouri's longest-serving death row inmate. He has been there for 41 years and 120 days. He was sentenced to die for the murder of an 18-year-old girl in Kansas City in 1983. He will die instead somewhere inside Missouri's correctional system, not in the execution chamber, because a governor got on a plane and did not land. Jody Harless was 18 years old when Bolich killed her in 1983. She has been gone for more than 40 years. The man convicted of her murder is still alive on Missouri's death row. The state sentenced him to die. Then a plane fell from the Missouri sky, and the resolution fell with it, and in more than 2 decades since, no one has found another way to reach it. Final outcome: William Theodore Bolich, Jr., remains on Missouri's death row as of early 2026, the state's longest-serving death row inmate at 41 years and 120 days. He will not be executed. Governor Jay Nixon's office determined that definitively. The stay granted by Governor Mel Carnahan in 1997 cannot be lifted because the man who granted it died in a plane crash on October 17, 2000, and a court determined that only he, that specific individual, that specific governor, could ever have undone what he set in motion. Jody Harless was 18 years old. She was murdered in Kansas City in 1983. The system that convicted her killer sentenced him to die. Then it lost the key. And in 41 years, it has never found another one.